Former President Trump, again, facing his third indictment, most likely for an entirely different set of alleged crimes, and is going to need 3 different defense strategies for each of these cases, potentially.
Yeah, so joining us now to discuss what his strategy might or should be for this latest case is Michael Sterling. His law firm, 925 Sterling Legal, has represented politicians, public figures, and celebrities. He's also a former assistant U.S. attorney in the Northern District of Illinois. Welcome back to Morning Rush. Good to see you.
Good to see you. Thank you for having me.
Of course. So we don't know what these charges are. What do you think the likely charges are, and how would you defend them against them?
Well, when you look at what other people, the other 1,000 or so people who've been charged with, the most likely charges are going to be conspiracy to obstruct a congressional proceeding.
Okay.
So because Donald Trump, obviously the other charges were, remaining on federal grounds illegally, which he didn't do, obstructing police officers, which he didn't do. So when you look at the other charges, the most likely charge is going to be that he engaged in a conspiracy to obstruct an official congressional proceeding. And so the idea is going to be, if this is a conspiracy, they're going to have to prove that there was some agreement. And the way legal conspiracies work, the agreement does not have to be explicit. It doesn't have to be a conversation that we're going to do this, but it can be implied by your conduct, by the circumstances. And so if I'm looking at what everyone else has been charged with, the most likely charge, and the fact that he's received a target letter, means that the DOJ is very close to an indictment.
And according to the New York Times this morning, other charges may include conspiring to defraud the government, the fake electors part of this, and also the mail and wire fraud, because he was raising money, a lot of it from supporters under the guise of, hey, this election was stolen from me, and that's why his mindset is important. Did he know that he lost, which witnesses say he did, but still acted in certain ways? His mindset is critical here.
Yeah, absolutely, because for every crime, no matter what it is, with the exception of misdemeanors or statutory, strictly construed crimes, you have to have what's called a guilty act and a guilty mind. So it means that what your mental state was, what your intent was, is going to be extremely relevant. So the question becomes, did he know he had actually lost the election, to your point? And if he knew he lost the election and continued on because everyone was telling him, hey, you lost the election, but was somehow trying to overturn the election, despite the fact that he was fully aware and cognizant of the fact that he lost, then certainly that's going to play a critical role. And how do you determine what he was thinking or what his mind state was, right? The people around him, what did they say? What did they see? Things that he wrote, text messages that he sent. All of that circumstantial evidence will be critical in determining what his actual mental state was.
And that's why it's so important who has talked to this grand jury. Mark Meadows, former chief of staff, who's kind of gone missing, gone quiet, and they're wondering. Mike Pence, Jared Kushner, Giuliani, inner circle people have spoken to him, and no other target letters we know of other than Trump, which does suggest to some maybe some of these people really sang and got a deal so they wouldn't be charged.
Yeah, so what happens is the DOJ sends out 3 different types of letters when they want you to potentially testify in front of the grand jury. A witness letter, a subject letter, and a target letter. Witness letter means we don't think you engage in criminal activity, but you have information that's relevant that we want you to talk to us about. And the target letter is the very exact opposite of that. It means that we believe you engage in criminal activity. We're getting close to an indictment, and we want to give you the chance to come and talk and maybe tell your side of the story. Usually when you get a target letter, your lawyer is going to say, don't cooperate. Let's assert our Fifth Amendment right. And then in between those two is a subject letter. A subject letter means, hey, we're suspicious of your activity, but we're not quite ready to say you engage in criminal activity, but we want to give you a chance to come into the grand jury and explain yourself.
So there isn't a shortage in this situation of audio, text messages, video of the riots, right? And the subsequent deaths that happened after that, whether it was by suicide or in the actual act of the insurrection. From your vantage point, from your job, how would you start to defend the president's actions? What would you do?
Well, anybody who's going to defend the president's actions are going to have an uphill climb.
Yeah.
And obviously you've got a really tough client, because he wants the trial to be by media. He's taken what I call the Governor Blagojevich approach. He wants to put everything out there. He wants to use Twitter and social media and everything to try to talk about the case. He wants to take this scorched earth approach. Typically what I would tell my client is be quiet. Don't talk. There's nothing for you to say. Let's assert our Fifth Amendment privilege, because the things you say will be obviously used against you in the courtroom.
Can I ask a deeply cynical question? People questioned why Special Counsel Jack Smith did the classified documents case in Florida. He could have brought it to another venue. And obviously where this case is in Florida, red area, Trump country. Do you think at all that Jack Smith said, okay, I'll let you have the Florida documents case on friendly territory because I know what else is coming. And what else is coming is the January 6 charges, which will be in D.C., where 95% of the voters in the district voted against him. It is very anti-Trump turf. So I'll give you this one. So I know this one. So it had to be in D.C. It's where the riot was. But he knew the jury pool very different in the nation's capital than it is in Florida.
Extremely different. Certainly jury pools play a role. But I think Jack Smith is probably trying to be as careful and as cautious and as above the board as possible. So in terms of the document case, the classified documents were kept in Florida. They were stored there. They were asked to be returned from there. They weren't returned from there. So obviously the venue choice was probably more obviously Florida, simply because that's where the classified documents were and they weren't going to be returned. Not to mention Jack Smith probably didn't want to go out of his way to choose a venue that wasn't friendly to President Trump. So wanted to give him the benefit of the doubt because he wants to maintain the public integrity of his investigation.
All right, Michael Sterling, as always, thank you.
Thank you
we appreciate
very much.
your expertise.
Please come back. No shortage of news on this.
My pleasure.
All right, Lindsay, over to you.